Guidance, Mr. Speaker. Also looking at the time, maybe you can guidance on the number of minutes we can take on this, the senators, and also the how many minutes can one senator use on the floor, Mr. Speaker.
Honorable Senators, if you strictly apply the rules of procedure, then you have 2 minutes. Proceed. And 2 minutes it is.
Thank you, Honorable Speaker. My question goes to Counsel for the Governor. And Honorable Speaker, I would like to refer him to Volume 1 of his documents. At page 7, Honorable Speaker, paragraph 20, there is an averment there, Counsel, that has been made by the Governor that in fact there was a holding of the High Court, and this is in reference to Malindi ELRC petition number E006. I don't know if we are together. Counsel, page 7 of the bundle at paragraph 20. Counsel, the volume number 1 of the Governor's bundle, page 7, for heaven's sake, Honorable Speaker, my time is being wasted by things that I've already said.
Just proceed.
Honorable Speaker, I'm referring to bundle, volume 1 of the Governor's
Senator
bundle.
Sifuna, you
at
can
page
only
7.
repeat if I tell you to repeat.
Thank you, Honorable Speaker. Counsel, you have presented the averments at paragraph 20A as a holding of the court. That in fact, the paragraphs you have superimposed there were a holding of the court. Now, you are a lawyer of great repute, and reading a judgment, you can ascertain what a finding of the court is, as opposed to an analysis of the presentations of the parties. Honorable Speaker, the judgment referred to is at page 70 of that same bundle, exhibit number 1. And I want the Counsel for the Governor to confirm to this House that in fact, the paragraph quoted at 20A is not a finding of the court on the question of what 2/3 means and what should happen when there is a decimal. Honorable Speaker, I will refer you to paragraphs. He has quoted from paragraph 83, which cannot be a holding of the court. And in fact, the holding of the court should be at paragraph 86 of that judgment. Honorable Speaker, my question therefore to him is it proper for you to present an analysis of the case by the learned judge as a finding of the court? Honorable Speaker, that is the question I wanted to put to him.
Senator Boni.
Thank you, Mr. Speaker. Mr. Speaker, my comment on this will be limited on what I beg that the House adopts to help this country. This is a very serious matter, and Mr. Speaker, it is already on record that no court can injunct Parliament. So the first PO should collapse. A decision has already been made. My second comment, Mr. Speaker, is on the question of numbers. Kanzo Mutuma, what would you like the Governor to prove? It is a scientific fact that 47 divided by 2/3 is 31.3. As you guys say in law, res ipsa loquitur. It proves by itself. What do you want him to prove? It is not possible for a human being, Mr. Speaker, to be a fraction. I want, Mr. Speaker, to urge the Council that because you also have a responsibility to grow the philosophy of impeachments, let us agree that on this one, let us give it to the Governor. We give him the fact that a fraction of a human being does not exist, Next time, come with full numbers and we would listen to you. Finally, Mutuma, because you're very experienced in this process, listen to what the Speaker of the National Assembly said about the same thing. The County Assembly of Nyamira said about the same thing. The County Assembly of Kericho about numbers during elections. They have said the same thing. So why do you invite us to disagree with all of them? So as to please you or to allow the proper jurisprudence?
Senator Ledama.
Thank you, Mr. Speaker. Mr. Speaker, I just want some clarity from the Council of the Governor. The Council for the Assembly has presented facts that this matter had already been determined by a court. In their Volume 1, page 131, there's a finding of the court that when it comes to the issue of two-thirds, it is not an issue where you determine the question of a human being being able to be fractioned, but rather a scientific. Are you then, in your submission, questioning, or rather, have you challenged, or has anyone else challenged that finding of the court in the matter of Michael Justin Dunda with the County Assembly of Tana River? So that is a point that I'd like you to clarify, because this is a finding of the court. Number two on that issue is on the finding on the matter to deal with JSC, where the court, according to the facts presented by the Assembly, stated that you round off to the nearest whole number. What would be the nearest whole number in a matter which is 31.3? Is it 31 or is it 32? Thank you, Mr. Speaker.
Senator Fernandez, Senator Samson Chirange.
Mr. Speaker, you need to protect me from the majority leader. Mr. Speaker, I want to agree with my colleagues. Just a quick comment is that in the history of this parliament, no one can injunct parliament. So I think on that aspect of injunction of parliament or court order before the parliament or the Senate, it does not hold water, and therefore I think I would advise the defense team of the governor to stop pursuing that line. Number two, and finally, Mr. Speaker, on the issue of two-thirds, Mr. Speaker, my concern is on Section 33 of the County Governments Act and Article 181 on removal of governor. Mr. Speaker, and in the decision of Raila Odinga versus IEBC in 2013, the Supreme Court pronounced itself that when the process, and I want to extrapolate, when the process has taken off and it is time-bound, as envisaged in that ruling before the Supreme Court, that process is time-bound. So by the fact that you read the charges and the process is ongoing, when you look at rule number 16, rule number 14, and rule number 30 on the removal of a governor, the process is already ongoing and the train has left the station. So, Mr. Speaker, the question should be, if the process has already begun, as per Section 33, with the genesis of Article 181 on removal of the governor, therefore, what happens, Mr. Speaker? I agree that in scientific proof that you cannot have a fraction of a human being. But also, for some of us who are not very good in mathematics, there is also principle of truncation. So, Mr. Speaker, you must balance both so that at the end of the day, we give justice to the county assembly and we give justice to the governor and any other person, including the people of Kericho, Mr. Speaker. So since the train has left the station, let us go ahead and listen to the merits and demerits of the case, and then we determine. I submit, Mr. Speaker.
Senator Kajuang.
Mr. Speaker, the issue of limits of judicial authority on independent institutions has been settled. And I think we have seen some precedents that have been presented to us. Secondly, we need to make a distinction between procedural fairness and procedural technicality. procedural fairness demands that the governor for Kericho has been accused of gross misconduct, and all sorts of allegations have been made against him. This is his opportunity to defend himself against those allegations. There should be procedural fairness as required in our constitution. The other aspect is procedural technicality. Mr. Speaker, you do recall that if we were to be obsessed with procedural technicality, in 1992 it is John Harun Mwau who would have been the president of Kenya, because he went to court and said he's the only one who presented his petition in a foolscap rather than on an A4 paper. Mr. Speaker, the ruling that has been referred to by both parties, we are getting different interpretation. On this matter, we should not go with Rule 30. Rule 30 empowers the Speaker to make a decision. Mr. Speaker, I want to encourage, the way we did in the case of Nairobi Governor Sonko, there were affidavits that were sworn by MCAs that discredited the outcome of the vote. The Speaker ruled that let's allow all parties to prosecute their case, and then the senators sitting as a jury would make a decision on the ultimate day of voting. I would propose and I would urge, Mr. Speaker, that we do not refer to Rule number 30, but allow the House to proceed and ensure that there is procedural fairness in the matter of Kericho.
Senator Kathuri.
Thank you, Honorable Speaker, for this chance of the 2 minutes also to make a comment on this very, very important matter. And Mr. Speaker, as we are here, many Kenyans are watching at us. They are grown on their TVs because, you know, many Kenyans are now sensitive on devolution, sensitive on governance, and all these things. So, Mr. Speaker, the PO number 1 is actually dispensed of naturally. So the PO number 2, Mr. Speaker, besides, because that 1.3, the High Court pronounced itself that you go to the nearest whole number. When you go to the nearest whole number, you run at that one, Mr. Speaker. The other argument is about now the direction that has been put in Kericho County when they were electing the Speaker of the County Assembly. So, Mr. Speaker, because this matter is about mathematics, so what I would request, as also other colleagues are putting it, Mr. Speaker, we would like to hear these cases. We give the Kericho County Assembly and the Kericho County Governor time to prosecute their matter before this Senate, Mr. Speaker. Because if we determine this matter in any other way, rather than listening to the parties, then we will not be giving justice to the good people of Kericho and the country at large, Mr. Speaker. So Senate will be a house that cannot be able to protect the devolution, Mr. Speaker. So in my submission, I wish that we are able to listen to both sides, and then we are judges. This is a High Court sitting, Mr. Speaker. We will be able to make our determination in one or the other, Mr. Speaker. Thank you very much.
Senator Wambua.
I thank you, Mr. Speaker. Mr. Speaker, two things. One, I don't know why my colleague, my friend, Senator Alwale would want to pick and choose on court rulings. A precedent has been set in the court, and he has quoted it, on the matter of separation of powers, that no court can injunct a parliament in its deliberative roles. And so PO number 1, everybody agrees it falls on its face. Speaker, then PO number 2. You know, what the lawyers on both sides are asking these judges here to do is a very complicated matter. It's a matter of determining a fraction of a human being. What is 0.3 of a human being? Is it the head? Is it what is it? But the Speaker, again, the courts have pronounced themselves on that matter. And in the case of Tana River, they have said that in a matter like this, then you round off to the nearest whole number, which is 31. Mr. Speaker, there are substantive matters for determination in this motion that this House needs to be engaged in. And you ask me, Mr. Speaker, as Senator Cherargei has said, the train has already left the station. We are already in motion let us hear this case. Let's make a determination one way or the other. Mr. Speaker, I submit.
Senator Aaron Cheriot.
Thank you, Mr. Speaker. Mr. Speaker, the people of Kericho have quarreled, and we've come before this House to seek for justice. And we pray for nothing less than justice in the interest of the people of Kericho. I want to make two quick observations, Mr. Speaker. One is unanimous by what colleagues have said, that PO number 1 has been determined by not only by Parliament itself, by none other than the Supreme Court of the Republic of Kenya in Wambora 1, 2015, Mr. Speaker, where it has been firmly established on what you do with a parliamentary process, either in Parliament or at the County Assembly, once an exercise has commenced. Therefore, on that count, Mr. Speaker, I plead that the country appreciates that particular issue. Second and most important, Mr. Speaker, is on this issue, and I wish my good friend Senator Boni Halwale listens keenly to this. Mr. Speaker, there is what you call the hierarchy of law, where the Constitution reigns supreme. It sits at the top. And when a matter is not sufficiently addressed in the Constitution, you look for it in statute or legislation that we have passed here. Where there is none, Mr. Speaker, what follows a third after that is already established case law. Mr. Speaker, the Speaker of the County Assembly of Kericho, in his affidavit, and it is hereby presented in volume 8 of the documents from the Assembly, cited court decisions that have been made on this particular issue. Therefore, Mr. Speaker, I don't know on what basis you would want to fault the Assembly, because I have listened to Council for Governor and there is no citation whatsoever on their part other than application of mathematics and this theory that we want to be told that there is no half or quarter of a human being. I thought, Mr. Speaker, that being a house of procedure, we would establish what is a practice that has been established in our courts of law. Mr. Speaker, you know, what I find to be extremely curious, though, is a very dangerous invitation that the Council for Governor is sending out to you. I listened to him, Mr. Speaker, and he wants to lead you to make a decision that has never been made by any other speaker in this House, Mr. Speaker, where he wants you to make a determination on appeal and dismiss this case altogether.
Now, have a seat. Now, honorable senators, it is now 4 minutes past 1. We can only, during a morning session, prosecute business up to 1 p.m. And therefore, allow me to invoke Standing Order 34, 2A, to extend the time for 15 minutes. Thereafter, we shall rise for a break. We'll come back at 2:30 and prosecute this matter because it is of such a fundamental nature. I'll give you 1 minute to conclude.
Mr. Speaker, you are being invited to very dangerous path. Previously, before this House, in Mike Sonko versus County Assembly of Nairobi, and previously also in Ferdinand Waititu versus the County Assembly of Kiambu, such POs have been raised. What did your predecessors do? They let the jury make the determination, which is all the 47 delegations. Do not accept, Mr. Speaker, the invitation that is being passed on to you to make a determination on your own. The Constitution, nor our standing orders or legislation, never envisioned a situation where the Speaker could terminate proceedings such as this, Mr. Speaker, purely on a point of order. Therefore, I want to humbly request you, Mr. Speaker, that just as we do in legislation, let us make a determination on this PO. If it comes to voting, let it be the case, Mr. Speaker. But on your own motion, Mr. Speaker, in the interest of justice for the people of Kericho, allow us to listen to this case and eventually make a determination one way or the other. I thank you.
Senator Mogeni.
Thank you, Mr. Speaker. Mr. Speaker, what I had my classmate, Kenyan Katwa, say is to invite you to invoke Standing Order number 30 to make a final determination on this impeachment.
It is the rules of procedure. not standing order.
Okay, yeah, under, I think the third schedule, under the rules of procedure. Mr. Speaker, my understanding is the moment an impeachment lands on the floor of the Senate, it becomes the property of the jury, who are the senators. If these proceedings were being conducted by a special committee of 11 members, Mr. Speaker, you will never be invited to make a determination on the issue of whether a two-thirds was reached. That decision will be made by that committee of 11. By extension also, Mr. Speaker, the right people, the right person or persons to make a determination as to whether the threshold of two-thirds was reached during impeachment is the House sitting as Senate. I don't think, Mr. Speaker, you'll be setting a right precedent for you to take that power away from the elected senators. Council can invite senators to listen to that issue and make a determination. But I don't think, Mr. Speaker, sir, it is right for you to be asked to make that determination as our Speaker. And I agree with those who have spoken before me, Mr. Speaker, that precedent has been set. During the Sonko hearing, Mr. Speaker, similar matters arose before us, Mr. Speaker, on issues of quorum. But the Speaker then ruled that those issues be argued as part of the defense of Governor Sonko. And then the senators make a determination. I invite you to be extremely reluctant, Mr. Speaker, to take a seat where you will be sitting as a jury and making a determination to either acquit or convict the governor for Kericho. That is a mandate reserved for us senators.
Senator Rober.
Thank you very much, Mr. Speaker. Listening to both sides, there's an alleged evidence by court ruling that has been shared by the Council for the Governor, but the citation of court rulings shared by the Council for the County Assembly. Mr. Speaker, sir, as shared by my colleagues, there is a question of common practice globally, and the issue that deals with the issue of fraction. And then there is the law. And the matter before us is not an easy matter that can be prosecuted by making a simple decision of, for example, what you have been requested in the preliminary objection to make, that of maybe, in the words of the Council for the Governor, to, on the basis of just the argument of the threshold, determine that there is no case to be heard by this Senate. It is important that Senate, sitting as a jury and a quasi-judicial setting, to make that decision themselves, so that it also becomes other precedent-setting cases, as mentioned by various colleagues of mine in the House, of cases, governors appearing before this same Senate. Can you allow this Senate to make that decision by way of voting, so that it becomes also another precedent-setting rule, rather than taking the burden of making a decision that the people of Kericho are expecting, the issue before the Senate to be really listened to and adjudicated over by the entire Senate as to.
Senator Muma.
Thank you, Honorable Speaker, for giving me an opportunity to contribute to this. Honorable Speaker, I wish to support sentiments by previous speakers, but wish to point out a very important issue when it comes to the PO on the threshold. Mr. Speaker, I want to point out that in the past, when the threshold has been about gender, the math to surround it, to round off to below the figure has sufficed. An example, a point to demonstrate this is the very county assembly of Kericho. So I wish to call upon our colleagues to take note that the Kericho County Assembly has 47 members, only 16 are women. So even as you make a decision, depending on what decision you make, we may have to nominate one more. I also wish to point out that in the bundle of evidence by the governor's team, that they indicate that the speaker was appointed by 31 votes to 16. It is something you need to take note of. And thirdly, to take note of that the Supreme Court of Kenya was not nullified, the first Supreme Court, on the basis of the 2/3 gender rule. In fact, it was rounded off and actually allowed to sit even though it had not reached the threshold of 2/3 gender. So please consider all these, and let's not be, when it is a gender issue, we conveniently can round it off the other way, but not on the other.
Senator Newton.
Thank you, Mr. Speaker. I also stand to give my contribution to the effect that, as all those that have spoken before me have said, that the matter, the number one, has already been settled, and I need not address it, Mr. Speaker. Mr. Speaker, about rounding off numbers, this is something that we were taught in the first lessons of numeracy when we went to school. And it is obvious, Mr. Speaker, unless our teachers were very wrong, that we round off to the nearest number. And so, Mr. Speaker, 31.3 can only be rounded off to 31. And so, Mr. Speaker, I support the argument by the Council for the Assembly that then the Assembly was properly constituted, Mr. Speaker. Mr. Speaker, I would want to ask this House not to be invited to an exercise of splitting hairs. We should not be sitting here arguing whether we should round off to the nearest number or not, because that is something, like I've said, that was sorted out many, many years ago during our numeracy lessons, Mr. Speaker. Mr. Speaker, the issue of validity of the court orders that were issued and that have been cited by the Council for the Governor, Mr. Speaker, the validity has been questioned. And I do not know what then should be done before you make a ruling. But, Mr. Speaker, this matter is before the Senate. And like those that have spoken before me have said, it is only this House that can determine whether we are going to admit these preliminary objections and not you, Mr. Speaker. And so I may want to ask you that you may rule that at the end of it, that we may vote on this matter so that we as senators, the members of this jury, may decide whether, by a vote, whether this matter should proceed or not. Mr. Speaker, please don't allow yourself to be the one making this decision, because if it were a committee, like Senator Mogeni has said, Mr. Speaker, you would not be sitting there. This
Now, honorable senators, it is now 1:15, and having concluded the business for which I extended the hours of sitting, pursuant to Standing Order 34-2A, the Senate stands adjourned until today, 14th of October.